What's up, everybody? Welcome in and get comfortable because we've got a lot to cover on today's video. We are going to hit Judge Glanville's potential recusal. What's going to happen there? The Supreme Court order. What did he say about it? Then we're going to get to Judge Glanville releasing the entire ex parte transcript from that secret hearing and meeting that was had between the judge, the prosecutor, a witness, some lawyers, some investigators. We're going to dig into all that. I've got my dad on to help break it down. It's going to take a while, but we're going to make sure we get all the important parts and explain to you exactly what we think is going to happen and what's been happening in the background as all of these steps are taken. So hit the like button, subscribe to our page if you haven't already. Let's jump into it. All right, Dad, the first thing we're going to watch is the short clip of Judge Glanville basically making it seem like he is agreeing to have another judge take a look and make a decision as to whether or not he should be recused in this case. And he also makes a very important statement that they are pausing proceedings of this trial temporarily, which, while is probably the legal right thing to do, kicks everybody in the gut a little bit because delays are not what anybody wants to hear at this point in the trial. So let me pull that clip up. All right, here we go.
And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it, and until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point.
So he kind of indicates there that maybe this will happen sooner rather than later, and maybe even will be taken care of before Monday when the jurors are supposed to come back after the 4th of July holiday. What are your thoughts and comments about the Supreme Court's ruling on the writ? Because they did not recuse him. It wasn't technically a big win for the defense, but they did enough, obviously, to push Judge Glanville to make this decision to let another Superior Court judge. Now, this is somebody that works with Judge Glanville and will know Judge Glanville, so that will help him a bit, I'm sure. But they pushed him enough to make this decision that somebody else is going to make a call in this case.
Well, first off, the writ of mandamus that went to the Supreme Court threw it out on technical grounds, saying that it should have been filed in the Superior Court first. They didn't follow the proper procedure, all that stuff. And they didn't have to say this, but they did. That if they do file it before Judge Glanville, he has to assign another judge to hear the writ of mandamus, because the respondent, in other words, the defendant on the writ of mandamus, they're called respondents on writs. The respondent would have been Judge Glanville. So since he was a party, another judge has to hear it. That was a signal to Judge Glanville that somebody else needs to hear this, because if he files a writ of mandamus, he's going to have to send it to another judge anyway. So he got a clear message from the Supreme Court. Right.
And Judge Glanville is going to do that at this point, and he is going to let another judge take care of it. He's not going to fight it anymore. He's not going to. And another reason is the Supreme Court's basically saying it should start here. This is where the writ should be filed before it gets to us. That's kind of the technical part you're talking about, which is fine. It's not a loss for the defense. Technically, it ends up being a win because they do want, it's not a home run, right, where he just gets recused and they get to do this the way that they want to. But at the very least, another judge is going to look at it and hopefully bring an unbiased view and opinion on to what should happen next. And all of this really boils down to an ex parte quote unquote secret meeting between Judge Glanville, prosecutors, investigators, Kenneth Copeland, who was a sworn witness at the time, and his stand-in attorney. So the big fight.
Go ahead. No, go ahead.
The big fight has been around this transcript. What was said, what happened, and Judge Glanville said he was not going to release the transcript. Then he was going to release it, but he was going to redact the privileged information. Nobody could really figure out what would be possibly privileged in this ex parte hearing. So now there's been another hearing where Judge Glanville has made a decision on what he's going to do with that transcript. Is he going to release all or part of it? What is privileged, if anything? And what does he want to take judicial notice of? Because all this is really important, because we are also supposed to have a show cause hearing for anybody to come out and say, whoever was in that meeting, come and tell me in the court that you didn't tell everybody what was going on in there, because that would be a really bad thing. And I may hold you in contempt. I may sanction you. I may throw you in jail. Well, all that becomes moot if he releases the entire transcript, right? So that's why this hearing is kind of important here that we're going to listen to next.
Well, and what he said at other portions of that particular hearing was the name is going to be put in the normal course of events. It's going to go on the wheel, which means a random selection of a judge that's going to hear it. However, there is an argument that the JQC, the Judicial Qualifications Commission rules in Georgia require a judge from another circuit to hear it, since he's the chief judge of that circuit. So there's going to be an argument about even which judge is actually going to hear this.
I mean, to me, that just makes too much sense. Obviously, it should not be a judge in his jurisdiction where he's the chief judge. That seems obvious to me, but common sense and the obvious answer doesn't always end up being right in law. But we'll see. At the very least, some other judge other than Glanville is going to take a look at this. And I don't think they want to be stained and throw themselves under the bus for Glanville if they really think he did something wrong. So we're going to hope the judiciary is going to make the right decision, whoever ends up getting called up. But I think I agree with that, and I love that idea that somebody outside of his jurisdiction will make the call. Okay, so now we're going to transition into the hearing where they discuss the transcript.
As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript.
So right off the bat, first thing he says is, we are going to release the entirety of this transcript. So what does that tell you about privilege and what was potentially going to be redacted or blocked from the public or from the defense attorneys?
There is nothing privileged. Nothing needs to be blocked. Everything that happened at that hearing, the defense lawyers can know, and they could have heard, and they could have been there. And these, I guess it's been 2 weeks that we've been dealing with this. I think it was the 12th that he had that first hearing. In the last 2 weeks have been a total waste of time. And he could have released the transcript, told everybody he was going to release it on the first day, and it certainly would have shortened the process.
To me, all it makes me think is he didn't fully remember what happened in the hearing. So he wanted to take a look at it himself and see how bad it was potentially, and if there was any way he could have blocked anything. But overall, I mean, we're going to dig into the details, and there are some pretty shocking, horrifying, terrible things that happened in that hearing with respect to a criminal defendant's rights. But most of the gist was what people were reporting and talking about happened in this hearing. But we're going to get into the details once we get to the full transcript. But let's hear him take judicial notice, make a couple other decisions that are very interesting as far as what's going to happen now.
Of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as courts 2. So the transfer will be court 1. His immunity agreement, Mr. Copeland, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick.
The timeline is important because he was granted immunity before he pled the Fifth, which is why he was thrown in jail. If that would have been backwards, it may have been different. We'll get into that a little bit more as we read the hearing transcript.
Informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival.
All of this, by the way, is noted in the transcript that we'll look at too. When they took a break, when the court was in the room, when the Kenneth Copeland was in the room, because he was not in the room for the entirety of the hearing in the transcript, which we'll see.
The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall.
It's a bunch of cops. It's like 4 to 6 cops standing in there with the judge and a couple prosecutors with Kenneth Copeland. How do you think he felt? Do you think there was any coercion? Do you think there was any pressure? Or did you think he just felt free, like he was represented by his lawyer and he could say whatever he wanted to? Right?
That was the whole idea. I mean, it was designed. These things are designed this way. I mean, that's the whole point. And there were people in there that didn't have to be in there, but they were all in there.
Be there, but the defense didn't have to. It's crazy.
No, I'm talking about there are investigators. They just packed that room.
Right.
The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams.
Oh yeah, we don't want to forget that.
The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor, entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court upon information and belief stated to the court, which are still on.
This is all for his order, because he's making an order, releasing the transcript, wants to give the timeline, and wants to say now what Mr. Steele said and take judicial notice of them.
Known. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which of course already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
And these are important for us to listen to these now, before we read what actually happened in the transcript in the hearing, because these were Steele's big gripes and big problems. And the court is putting them on the record before anybody gets to read the transcript. So it's important to know what the beef was that the defendant had, because if none of those came true in the hearing, then it would be a moot point. But if they were legit, then there might be a problem, right?
Oh, yeah. That's the whole issue. But again, he has to presume that they're true when he's reading these.
Right.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage.
So he's basically saying he thinks that's when Bumpus told him what happened in the ex parte hearing, right?
Well, that's what he's saying, but later on we're going to talk about it, but I don't think that's what happened.
And only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for
Then why mention it?
the purposes of considering the security and breach of information that occurred within the court's chambers, not for the whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage, and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication, and gives parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier.
So just that right there says, if the judge inadvertently becomes aware of ex parte communication, he should let everybody know.
Right. That's the notice requirement. That's the way you can cure a lot of problems, by telling everybody, what happened.
Which we've seen in lots of trials. It's like, hey, I just want to put everybody on notice. This happened. You just cure it, and it shows you're not doing anything nefarious. You're not trying to hide anything. You're not doing anything slimy. But he didn't do that here.
Well, like a lot of things, the cover-up is worse than the actual crime.
Exactly.
I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland.
Which is exactly what the defense asked for.
I'll address the issue of the emergency nature of this particular hearing, or this particular conference in front of the court, is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement.
So he says no tactical advantage, basically nothing the defense could have used, nothing the defense could have learned from being there. It was just a discussion about his immunity agreement and making sure he understood.
Well, what he's doing is he's given his defense, and he's presenting his defense, and he's not presenting his defense for any reason, because his defense is going to have to be presented to the judge that here's the recusal motion. This defense is strictly for the cameras because there's no reason to do it otherwise.
Right. And we're going to read the ex parte hearing. He knows that. Everybody has the transcript at this time. He knows people are going to disagree with those statements, including us, that no tactical advantage, no pressure was put on this witness, nothing the defense could use or learn from this hearing. Though that's what he's saying right now, which is just not how I see it, I'll just say.
Consideration of these of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. We cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant.
A lot of these are witnesses or jurors wanting to speak to the judge.
We agree with the First Circuit. The ex parte conference is appropriate in that situation. They see United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got the citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed, and second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and judges' comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the only promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed.
Do you see any of these as being the situation we had here?
Well, no. I mean, there's not direct correlation of the facts.
I don't see any of them. I see major differences between all of them.
Yeah, there's not a correlation, direct correlation. But it gives him general propositions of law, which is what he's talking about. That's what he wants to do, is make things sound like there's cover for him to do this.
Exactly. He's saying like, this isn't the only ex parte meeting or hearing that's ever happened.
Right.
Happens all the time in cases like this, and the defendant doesn't have to be present. But it's like a jury getting threatened, or stuff happening is not the same as what happened in this case, or a witness even wanting to talk to a judge. That's very different than what happened in this case.
And they also deal with direct threats, which is something we'll talk about when we go through the transcript.
Exactly. I'm going to refill my water. We're going to keep listening.
Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. In the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of the criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on looking at the case law, that that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, then the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge.
So, but that the defendant doesn't necessarily have to be there, but his lawyer should have to be there. That's the point of is represented by counsel.
Right. Somebody has to be there.
Right. But he's making it seem like, oh, no, the defendant doesn't have to be there. If it's just law stuff that he can't understand. It's like, yeah, if represented by counsel, which would infer that if he's not represented by counsel, he would be allowed to be there, because if his lawyer
this is designed for the cameras, because people out there that aren't lawyers are listening to this and they're thinking, wow, you know what? This makes a lot of sense. But when you really break it down, it doesn't make sense. He's just covering himself.
Yeah, I don't know how many people are buying it at this point, but I get what you mean.
It is well settled under the Georgia Constitution guarantees the criminal defendant the right to be present and see, hear all the proceedings which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow. Takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and/or our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sure. As a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024, as I mentioned earlier.
So that's off. That's canceled. No need to have the show cause hearing, right? Because now the transcript is released. So there's no violation because everybody's going to know what happened in that secret meeting, including all of you watching, right? So these people had to hire lawyers. They had to pay legal fees. These lawyers had to prepare for a show cause hearing. And the judge is just like, actually, I'm just going to give out the transcript. Maybe somebody else was right. Maybe I was wrong. I'm not going to say that, but you're dismissed, sir. You have nothing left to do, right? I mean, that's crazy that that's what happens.
They also filed motions to quash. They filed a bunch of other motions. And if you remember at the very beginning of this, Banks's motion for recusal was part of the recusal that he's sending to that other judge. That's going to be moot. But he did mention Banks's name when he listed the recusal motions that he had. So they also filed a motion to recuse him as well as everything else.
Yeah, and it's really crazy to me that this stuff just happens and people have to pay for lawyers and they have to do all this work when they were right at the beginning. And before it even gets settled, they're just like, never mind. But that's just a brutal part of our system. All right, well, listen to the last minute here of this hearing.
We were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing. Okay. All right. And then then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's.
So this is the minute we heard at the beginning. I just want to play that first so we can handle the clip of the fact that he is going to have another judge take a look at the recusal. Any other thoughts on that hearing before we jump into the transcript?
No, but it's interesting that the one thing he didn't do is he didn't dismiss the contempt against Steele. He didn't do that. So that's still out there pending.
That's interesting. All right. Here we go. Transcript of the ex parte hearing, Judge Glanville, June 10th, 2024. So here's present in chambers at this point at 9:10. Glanville, District Attorney Love, Attorney Kayla Bumpus, who is Kenneth Copeland's attorney, reporter. What is that?
Guy cleaning the outside of the house.
Okay, I'll mute your mic and I'll unmute it when it's
go ahead and mute it.
Okay. Okay. So present is Glanville, District Attorney, attorney for Copeland, court reporter, and 2 investigators at this point. Judge says he's ready. Ms. Love, the ADA starts. That talks about twofold concern. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him into the courtroom when the jury comes out. The second concern that I have is I wanted to bring to the court's attention in line with the concern that I expressed on Friday. I don't know what advice counsel may be offering or may be offering. That is their right and their business. So why is that a second concern? That she's worried about what advice a criminal defense attorney is given, a witness potentially looking at criminal implication.
I'm sorry, you may still be able to hear some of it outside there, but
you can just talk first. You can just talk normal.
Okay. Go up to the top, and the interesting thing is you do not see the judge saying anything before this starts. How is that possible that the judge didn't say anything before this hearing starts? And it starts out, the first person speaking is Miss Love. That's number one. Number two, the judge makes no determination as to why this is an emergency motion. Why doesn't the defense have to be here? Ms. Love, before you talk, explain the emergency nature and why the defense cannot be privy to this information. None of that. So we start out with love. So you know that there was stuff talked about and said before this transcript started. I mean, it defies logic to think that there wasn't. And then you look at these two particular issues. Where is the safety of the witness? They don't really worry about the safety of the witness. They're more worried about the fact that they're not getting their way with the witness because the witness has a lawyer that's not letting them get their way. And so they don't like that. So they want the judge to take care of that. And they want the judge to intimidate the witness so he testifies. Basically, that's what they're saying.
So it also comes down to, he talks about, or she says, as it relates to testifying, I don't believe criminal exposure is a concern. It's like, well, you're the prosecutor. So it's not up to you to advise a potential criminal defendant on what the criminal exposure is. So she is, to me, this prosecutor, as we read this ex parte hearing, does not live in reality. Like, I would never act how she acts, and acts like she has all the power to do whatever she wants. And if she says it, everybody's got to listen to it. The judge, the prosecutors, the criminal defendants, the witnesses, and she just, whatever call she makes is all that matters, which is just not true. And it's not correct. And she misunderstands so many different aspects about how the attorney-client relationship works when you have potential criminal liability.
Well, I've got to, I've been a state prosecutor and I've been a federal prosecutor. She's embarrassing. And I was the chief of the criminal division as well as the felony division of the state attorney. If I had an assistant that said these things and acted like this, I send them back to school. She missed the boat somewhere in her training, and she's, I believe, the chief assistant. I believe Miss Love is the chief assistant
to handle this case, which is a very big case.
Right.
But then
it's terrible.
So then she says, Mr. Melnick relayed to Miss Hilton, which is the other prosecutor, on Friday that he never heard of statute 245507. And on Friday sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele, Mr. Shart, with me and Simone, where he said, this is the communication I received from Miss Love regarding Mr. Copeland. First off, I don't think that was a mistake. I think he wanted the other criminal defense attorneys to know what's going on and what the prosecutor's telling him. There's nothing wrong with that.
Well, first off, it's one of the things the problems that prosecutors have is this is a full disclosure. He told everybody what was going on. It was no secret. And the other thing is, think about this. They do an ex parte hearing, and what do? They bash the defense lawyer who's not there and telling the judge, look, this guy is stupid. He doesn't know the statute and he can't defend himself. He's not there. So they just rip him.
My response was, whose interests are you protecting? Yours or Mr. Steele's? Which client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shart's? He wrote back saying, you are going to get him killed. You are making him a target. F you, is what he wrote in the email. So again, do we really think she cares about Mr. Copeland's best interest? She cares about her case, what she wants, the testimony she needs, and she's trying to make it seem like he's doing something shady when in reality, witnesses for the prosecution cooperate with defendants all the time. We talk to prosecution witnesses or defense witnesses all the time who tell us what they're going to testify to, whose lawyers work with them. There's nothing wrong with that. He's not beholden to the prosecutor's office. So for her to act like there's some wrongdoing here is just unbelievable. And then number two, he's basically saying what you're doing is putting Mr. Copeland in danger and you don't care.
But again, he's not there and he can't defend himself. This is an easy hit for the prosecutor.
Additionally, there have been stories that other people connected to Mr. Copeland have not done well since all of this. This portion about Mr. Melnick is also interesting as to whether or not he represented Mr. Copeland at the time. And it comes down to, and what we're going to find out is, he's basically saying if the prosecutors are having these off the record conversations that aren't recorded with Mr. Copeland, it's hard for Mr. Melnick to represent him if he's going to go testify. So if he's going to testify, he's not going to represent him. And the prosecutors are trying to make it seem like Melnick is doing something wrong in that situation.
This is another huge ethical problem for these prosecutors. Throughout this transcript, they admit that they had private conversations with Copeland without his lawyer there. They know he's represented. They know he has a lawyer, regardless of this garbage about Copeland saying, I wasn't represented, I am represented, the facts are there is a notice of appearance in a criminal case in a file where Melnick is his lawyer. Those lawyers are duty bound to recognize and respect the fact that he has a lawyer. Until the judge releases him from his duties as a lawyer, Melnick is that man's lawyer. And these prosecutors are just outrageous in the way that they're trying to manipulate Copeland to get between him and his lawyer. That's outrageous. Hopefully somebody's filing a grievance against him.
And what else is problematic and annoying is we're going to see in this hearing, and we saw outside in court how Glanville just wouldn't let the lawyers walk away from Copeland. They basically forced them to stay, which shows that Copeland randomly saying, I'm not represented, doesn't matter. And all lawyers know that unless a motion to withdraw is filed and then granted by the judge, because sometimes lawyers want to get off the case and the judge says, too bad, no, you can't. So it doesn't just go in and out like you're represented by counsel 1 minute and 1 minute you're not, which is what it seemed like through this. So then they kind of discuss, how long he could potentially be in custody, what Ms. Bumpus needs to explain to Mr. Copeland. Is it the end of this trial or the end of all the trials? Bumpus says she just wants to be able to give him, and the court said, I know. It's kind of a statute. It's kind of the statute says, that you purge, but I can't keep him there indefinitely because, again, they're discussing whether it's till the end of this trial or the 12 other defendants that haven't been tried yet. And then we get into, but what we overheard being said, and I believe this is the prosecutor again, overhearing conversations between Melnick and Kenneth Copeland, attorney-client privilege, private conversations that they are listening to. They are going to hammer you as if we're going to expose Kenneth Copeland to. Ms. Bumpus said, you heard that? And Ms. Love said, yeah. Mr. Melnick told Mr. Copeland we're going to hammer him.
Right. And then the court's comment right after that is interesting because the court is actually trying to explain that away.
Now, to be fair, as I think Ms. Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination, which is not what they were saying. And Bumpus said, I think that's what he meant. The court said, he's going to face, he's got about 10. And Love said, so he meant the defense is going to hammer him? Ms. Bumpus said, no, just in general, it's not going to be a, hey, da-da-da. He knew that. He's already been expressing that. Right. But here's the thing. He knows, like only Copeland knows what he knows and what he's going to say and what he's going to testify to. So maybe Melnick knows some of it too. Are we really supposed to believe that the prosecutor's not going to hammer him as well? If he lies or he says something they don't like or he pleads the fifth, he's going to get thrown in jail and he's going to get hammered on direct and he's going to get hammered on cross. None of these lawyers represent him. None of these lawyers like him. So it's a completely correct statement to say the lawyers are all going to hammer you throughout this process. And that's something the lawyer is advising him of that the prosecutor's overhearing. And she has no fear. Once again, if I did hear this, I would be like, oh, crap. I just heard attorney-client privilege information. I need to let them know that I heard it. I'm not going to use it in any future arguments or against anybody. That's what you're supposed to do. Instead, she just openly in front of the judge is like, Judge, I heard him talking to his lawyer, and this is what he said. I have a problem with what his lawyer advised him of.
See, what's happening here, and your listeners should recognize the fact that all the impropriety that's occurring here is the prosecutor. Everything that they're doing unethical, repeatedly unethical things over and over again. The judge's sin is that he's letting it happen. That's the difference. The difference is the judge may not be saying anything that's really bad yet, but he's letting the prosecutor go crazy and act unethically. And he still has not recognized why this is an emergency and why this should be an ex parte hearing.
Yeah. And again, the judge should have just said to her, Ms. Love, that's a privileged conversation. I'm not going to consider what you're saying there. Like, that's what he should say. He should not consider that statement.
Right. Or ask her, why were you talking to Copeland without his lawyer present?
Right.
That's a question he could ask as well.
Then Bumpus says he doesn't know what was said outside of his presence. Again, this is Melnick. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. That's totally fair, right? He doesn't know what his client told to the state. He can't advise him that's a lie. That's not a lie. That could open you up to criminal prosecution. That couldn't, because he doesn't know what's going to be inconsistent. He doesn't know what was happening in these conversations. And also, the state wasn't recording them. That could have been solved. They could have recorded them and then given them to Melnick so Melnick would know what was said, but they didn't do that. Then they start defining what a lie is. And by a lie, we don't mean like, oh, I think you're lying. I would love to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. Tell the truth. I don't care how bad it is. Just tell the truth. And they mean the truth, what they think the truth is. And even Copeland starts to pick up on that. Like, what if you think I'm lying? So they give some examples. Love says there's been an assertion that people are representing that their biggest concern is his best interest, and they're just not here. And Ms. Bumpus is saying she's not in position to do that. Bumpus says, I'm saying the agreement between Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says he discharges Melnick, which again, prior to this point, no discharge papers for Melnick. That's their agreement. I can't do nothing about that. Love said, that sounds weird. It does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I ain't going to. I'm not going to represent you. I don't even know what to do with that. Bumpus said, well, he said he does not know what was said. I think it's totally fair for Melnick and Bumpus to be in this position, don't you?
Well, it is, but Melnick, and the judge will go through this, Melnick, that really is not a good thing for a defense lawyer to say, that they're forcing him to withdraw if he testifies.
But don't you think his reasoning is sound in that if he testifies, the issues that will come up while he testifies, Melnick will not be able to represent him on?
Oh, absolutely. And you might want to file a motion with the judge, asking the judge to let you off the case because of that. But that's what you should do. Is file a motion with the court and have the court have a hearing on this information. But you're right. It's perjury. The prosecutor decides what perjury is. And, if they have statements that you don't know about, well, how can you defend your client?
And the issue was created by the state.
Yes.
Having these conversations without counsel present, from my opinion, those conversations should just be struck. They should not be able to impeach Mr. Copeland based on anything that happened in those conversations. There are ways to fix this where you could force Melnick to stay on. Meaning anything you don't know, Mr. Melnick, or you weren't there for, can't be used against Mr. Copeland. That's a fair remedy to me.
Except the judge cannot control what later on the state attorney may file a charge of perjury. Correct. The judge can't control that. He can control what happens in this trial, in this case. But later on, if there's a charge of perjury, the judge can't stop that.
Right. But what he can do is say you can't use that stuff. And if you are going to use that for a crime of perjury, then you're not actually giving him the proper immunity. So I'm not going to throw him in jail for contempt for not testifying. The judge can do that.
I don't know if he can. I'll be honest with you. I don't know if he can interfere with prosecutorial discretion.
But you think so? The judge has to throw him in jail if he won't testify?
I think if he keeps the fifth, yes, the judge has to throw him in jail.
Oh, I don't think that it's that black and white that he would be forced to do that.
I think so.
Okay. So next, Miss Love says, Copeland was like, hey, he's not my lawyer. I don't have a lawyer. We've already kind of heard some of that. So then we get to the fact that Ms. Hilton had a list of questions for Mr. Copeland, which I thought was interesting. And again, something that if defense counsel was in the meeting for, they might want to know. Ms. Hilton already shared the list with Mr. Copeland, and they'll share it generally speaking. Can I read this email Melnick sent? Can I read you this email Melnick sent me? I don't know if it'll help you understand what he's saying. So that's
Can I just raise one thing about that?
Yeah.
You see that where the court says, I thought that Ms. Hilton had a list of questions for Mr. Copeland.
Yeah.
Maybe I missed it, but I went back in this transcript. I don't see where the judge was told that in the transcript. So there must have been a conversation outside of what's in this transcript where they told the judge they had this list of questions. So that's another clue that something else went on before this transcript started.
And I think they've had hearings and talked about Copeland a lot throughout the trial, like even outside of this with the defense lawyers there. But the defense lawyers will know because they've been there this whole trial. They're going to comb through this and pick through this. And if there's more indications of that, there's going to be more problems. Ms. Love said, so he can't force Mr. Copeland to discharge him just because Copeland decides to testify. The court said, I think you are in until it's done. I mean, you know, and Bumpus says, who, me? The court basically says he's going to force Bumpus to stay on. And Ms. Love said she's in a tough position because she's not the one that interjected herself. Melnick is, and now she's standing in for Melnick. And they talk about the immunity agreement and how they're not going to use anything he says against him. They're not going to prosecute him for anything that he says. Of course, later they say, well, if he makes up certain lies, that could change, which we'll talk about. You're his lawyer. You're his stand-in lawyer at this point. Judge is going to force Bumpus to stay on. Love said we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded, again, as long as it fits the state's narrative. They basically qualify all their immunity in that. Do you think he's fearful of testifying for other reasons like personal safety? Bumpus said, right. Love said, that is what Mr. Melnick said to me in an email. I can pull it up. You're going to get him killed. Again, we already talked about that one. But again, there are other things going on and other reasons he might not want to testify. Then Glanville exits at 9:33. Love says, we just like to go into another courtroom and talk. Give you a chance to talk to him, meaning Bumpus to talk to Copeland. Glanville comes back 1 minute later. Miss Hilton has been communicating with him. I'd like to grab her as well. So Miss Hilton's going to join the party. Then they come back basically at 10:03. So they're in recess from 9:34 to 10:03. Again, while all the defense lawyers are just waiting out there. And who is now in the meeting? Glanville, 2 district attorneys, court reporter, 2 investigators, Deputy Houston, Deputy McPherson, Sergeant Brown, Sergeant Hall with the Fulton County Sheriff's Department. So 4 more officers. So now we have 6 officers, 2 district attorneys, and a judge in there with Mr. Copeland, as they're about to explain to him how bad this could get for him. Let me see something here. All right, so page 24 is when I want us to start reading a couple pages here. We'd like to hear your testimony. That's kind of where we are at this point. So is there anything you want to ask? So now Copeland's in the room. I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. So just that statement right there. If the defense counsel was in the room and he said this on the record, and now they have it, and I guarantee they're going to use it, is this not impeachment material for this witness that the defense is absolutely have a right to?
No, absolutely. The fact that he is that he doesn't want to testify. How many times does he say that? The fact that they have to keep threatening him. All that stuff is useful for cross-examination.
But specifically, if this is the state star witness and he said he's never been truthful a day in his life,
oh yeah,
that's pretty important for the jury to hear.
But apparently nobody else in that room thought so.
Right. There's no tactical advantage. There's nothing the defense could have learned or used in this hearing at all. Totally fair game.
Can you imagine a prosecutor not using, if a defendant ever said, I've never been truthful a day in my life? Can you imagine the prosecutor saying, oh, that's not important. I'm not going to ask you that.
No, I don't need that to prepare for trial.
Right.
Okay. Well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it. Hilton says, and what we'll say, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up, you can't. Like, there's nothing that can happen. The feds, and Bumpus said, well, that's not, and Hilton said, it is true. Bumpus says, no. I said, that's not his concern. If his concern is safety, we need to know that. Like, that's not expressed. So we don't know what the concern is, so we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concern is potential criminal liability, hence why we gave you immunity. The federal statute of limitations is done. The state statute of limitations, done. So there is nothing, like I researched it this weekend, but those statute of limitations for what you and I talked about, which is 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide, 4 years would have been 2019, finished. Next concerned, what may happen in the street. You know what we have talked about, what we can do as far as living and all of that. We have had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I have to tell you that. What I've got to say to you, we do not want you sitting in DeKalb or whatever they got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Ms. Bumpus, I'm here. This is a prosecutor saying, if you want to talk with or without your lawyer, I'm here. But we do not want you in custody. Go ahead.
Let me go back.
Okay.
The federal statute of limitations is 5 years. That's a lie. There are crimes that are 10 years. There are crimes that are 20 years.
What she's talking about. Do you?
No. And in fact, is she's giving him legal advice.
Correct.
She's becoming his lawyer, and she's lying to him, totally misleading him about the statute of limitations on federal cases. I mean, you know, she's a lawyer. She can go look it up. Where did she get the 5 years for all federal crimes? I mean, it's absurd.
Are you saying there's not a single federal crime that's got a 5-year statute of limitations?
Sure there are, but that's not all of them.
But she doesn't say all of them.
Yes, she does. She said he cannot be prosecuted. Said, don't worry, because there's no federal prosecution because the statute of limitations is 5 years. That's what she's telling him.
She said those statute of limitations for what you and I talked about. So I think she's saying she looked up the specific crimes that he told her he committed, and she's saying those are 5 years. She could still be wrong, but I don't think she's saying all federal crimes.
She is wrong. I'm just telling you, she is wrong.
Okay. Well, here's what I'm saying. You're 100% right in the fact that she shouldn't be giving him legal advice. And if she turns out to be wrong, like you're saying, and he does admit to something and the feds prosecute him, guess what? Too bad, so sad. You're going to prison because this doesn't hold. If she's wrong, he's the one that gets screwed at the end of the day, not her.
Right. And it's not his lawyer telling him that. It's the state becoming his lawyer.
Yeah, it's horrible. It's horrible. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, that's what the order says. And that is direct or cross, the judge pipes in, and that's direct or cross. So if you are worried about the defendants, they may ask you because they may know your business. But if they ask you about things that you might think you have some liability with, you can't be prosecuted for any of those. So that's even more wrong, like you're saying, because now they're saying crimes we don't even know about. And they're still saying those statute of limitations. So you're right. Mr. Copeland, I got family members watching this trial. I don't want my nephews to hear the things that I may be involved with and think it's okay. Ms. Hilton says, but I think that's a separate conversation you have with them as an honest individual. Like, look, nephew, I've lived through this life. I don't want you to live. Don't go through what I've been through. Again, pure legal advice, pure coercion, pure just telling him exactly what he needs to do and should do, forgetting about what's best for him.
Can I interrupt for a second? Maybe I missed where you read, close your ears. Did you read that part?
Have we gotten there yet?
Yes, the page before, page 26. And that you will not. Yeah, there you go. That paragraph.
You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, any of it, literally. Judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So the facetious close your ears, which again, these prosecutors have no fear that the judge is going to do anything that encumbers what they want to do and what their end goal is. They know this judge is not going to reprimand them. They know this judge is not going to tell them they're doing anything wrong. They know this judge is not going to shut down this, interrogation and threaten fest that they're having with a witness. This is just proof of that. And again, we all know there ain't no statute of limitations on murder. So the advice she just gave him prior is obviously wrong when she's giving this as an example. I mean, that's crazy. Could you imagine a defense attorney being like, Judge, close your ears?
Well, a defense lawyer will be arrested if he did this stuff. Defense lawyer would be in jail if he did this stuff.
Copeland said, y'all did this intentionally. She said, no, we did not. You and I had this conversation this morning. Again, all the conversations they had. But what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And I said, if you plead the fifth, and that's exactly what you did on the stand. So again, this also reminds us, and we think back to the defense saying they knew he was going to plead the fifth. And Copeland says multiple times, I told you I was going to plead the fifth. But then it seems like Hilton thinks she talked him into testifying by threatening to throw him in jail if he pleads the fifth. Then he still did it. So they knew it was an option, but they didn't think he was going to plead the fifth. I told you every day I was pleading the fifth. No, you didn't. I told you my concern.
Let me stop for a second. These things now, credibility now comes into play. Who do you believe? Do you believe the prosecutor who said he didn't, or do you believe him where he said he did? And if you remember, the defense during the hearing said they put him on the stand knowing he was going to claim the fifth, and they say, no, we didn't know he was going to claim the fifth, and he's saying, I told you every day I was taking the fifth. So this is totally inconsistent with what happened in the courtroom when the prosecutors were making their allegations about whether they knew or didn't know he was going to take the fifth.
I think it's pretty clear that they knew at some point he was going to plead the fifth, but I do think they have an argument that after they threatened him and coerced him, he said he wasn't going to plead the fifth. He said he was going to testify, and they believed him, and then that's why they put him on the stand. So I do think there's at least an argument for them there.
But who's telling the truth?
Go ahead.
Who's telling the truth?
Right.
Copeland, who never told the truth in his life.
Exactly. Yeah. The judge is probably not going to believe him, rightfully so. This week when we first met in the car on Friday, first met you in the car on Friday, which again is like, what? Is Mr. Melnick your attorney? You said he's not my attorney. I haven't even talked to him. No, I never said he's not my attorney. I said I haven't talked to him. So again, by the way, waivers of counsel and all this stuff and firing has to be unequivocal. Usually there's a colloquy with the judge so that we don't have this exact issue, because this exact issue is usually read in favor of the layperson criminal defendant who has a right to counsel. We believe that your truth is your truth. We know what you've said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. That's Ms. Hilton. They talk about immunity some more. The immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. So even Mr. Melnick told them officially Copeland is going to plead the fifth.
So how did they know? How did they think Melnick wasn't his client? If Melnick is sending him the emails, they're responding to the emails by filing an immunity claim. How can they claim Melnick is not his lawyer?
It's just basically whatever suits them. Whatever's better for their case at that point. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point, we gave him immunity, again, responding to that, responding to Melnick again as his lawyer. He could plead the fifth if he didn't have immunity. The immunity is what gets rid of the fifth, because you can only plead the fifth if you are doing something that could reasonably incriminate yourself. And if you have immunity, then what you're saying is not going to reasonably incriminate you. We've talked about this in other cases. If you testify, you get out of custody. You stay out of custody until you're done. And if you don't testify, you have to stay until when? And again, this is when they go over the 6 or 12 other defendants that they still have to try, so he could be in custody for a long time. And this is the judge getting involved as well, telling him exactly how long he could be sitting in jail. I do want to read this page. Ms. Bumpus, so explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? If he says he did something, he did not do that thing. If you believe he did not, so if you believe that he's lying about that, then no. If he admits to doing something on the stand, and he did not do that thing, I'm going to say, is this the first time you're saying that? And we have independent evidence to prove that it wasn't him. Then what? Then nothing. What do you mean? So then he will be fine. Yes, but. So you're okay with him if he got on the stand and said things that weren't true. So she basically said that she's okay with it, but then when it's confirmed, she says, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. So she's just speaking directly to the defendant or to the witness at this point. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that's inconsistent with what you said before, I'm going to ask you about the inconsistencies, but I expect you to tell the truth.
Just as a note, as a prosecutor, whenever I had a witness with immunity or anything like that, the last thing you always say is, the only thing I want you to do is tell the truth. Because during cross-examination, you know that a defense lawyer is going to say, well, what did the prosecutor promise you? What did they tell you?
Yeah.
So that you always have that statement, well, the prosecutor told me to tell the truth. So that's a statement you always make sure is in there preparing for the defense cross-examination.
All right, so then we get to Mr. Copeland. If I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Okay, so you can say I don't recall. It's from the state. That is how that works. I don't recall. The state literally telling him how to testify as a witness, which is very interesting. Ms. Bumpus, and he can say that to every single question. I would hope that's not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is if he says, I don't recall. What will get me locked up? What did I tell you? I don't know. What you did on Friday, I plead the fifth. If the court instructs you, so the only thing that gets me locked up is pleading the fifth. Yes. The court instructs you, you need to answer the question. You say, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. Mr. Copeland, so if you don't want me in jail, why you just don't let me go after the trial is over with? You are in jail because you are not answering the questions, because you have been given immunity. The judge piped in there. Because you've been given immunity, you're only in jail because you got up here. Well, what about this? I answer the questions, you take away immunity, I answer the questions, and I plead the fifth. He doesn't want immunity. He just wants to plead the fifth, which I think is very interesting. But one of the other issues I see here as well is she is not just giving him immunity. She is guaranteeing him immunity in every sense of the word, which she cannot do. She is telling him how to answer the questions, and she is telling him what is going to happen regardless of what his answer to the questions are, which she can't possibly do because she doesn't know what's true. She doesn't know what's false. She doesn't know what he knows. She doesn't know what he doesn't know.
Well, the point is, she's giving him immunity. And again, I think I said this in the last video we did before. Giving somebody immunity and not knowing what they're going to say is just incompetence. I mean, it really is. You should definitely know, what is this witness going to say that I'm giving immunity for? Because again, as he claims here, he flat out says, what if I say I murdered somebody? Or, he flat out says that. They said, don't worry about it. As long as it's the truth, you don't have to worry about it. That's crazy.
So then Copeland says, I won't plead the fifth to things that don't incriminate me. The court said, and here's the court jumping in, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent, and that Miss Hilton is telling you is just the truth as you know it, and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity, or as Miss Love said this morning, remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement. And Copeland says, that's what they're going to do. That is what I was saying. You will be right back here. But if you say something that you know you did not do, like you admit to something you know you did not do, like murder, don't have no statute of limitations, right? So he is correcting the prosecutor on some of the stuff she says. But if you didn't do it, I can't charge you with something that you didn't do. I don't have any other evidence but you saying it. Well, a lot of times that's enough evidence, or close to enough evidence. But y'all don't you can charge him with false statements and he will be back in jail. That is what I'm trying to say, Ms. Bumpus says. But and this is back to Ms. Hilton, but if I know you're lying about that, I do not intend to do that. So she's saying if he lies and says he commits even the ultimate crime, if she thinks he's lying, she's not going to prosecute him. So it's totally up to her discretion So she totally could prosecute him for it. So that's not an immunity agreement. That's her saying, I'm going to choose what I do and don't charge you with based on what you say, based on if I think you're lying. I'm not going to charge you because I don't know your reason for doing that, but I'm not going to charge you when I know you didn't do what you're trying to say you did now. And that can be part of this. I know you didn't do it. So this is the prosecutor now judging the credibility of a witness, basically saying when he's lying and not lying, basically entering the province of the jury, because this is what the jury is supposed to do. But it's up to the judge to do that. No, it's up to the state to bring charges. I don't have anything to do with that, the judge says. He has nothing to do with bringing charges. That's up to the state of Georgia. Then Copeland says, can I call? Can I talk to my family? I will make the decision right after I hang up the phone. He's saying he hasn't been able to speak to anybody, Bumpus said. His sister just called us, Hilton said. Copeland said, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, nothing. We have no knowledge. We did not know that he hasn't been able to do anything or speak to anyone. The jail system down, but y'all still putting people in. Ms. Hilton said, that part I don't know. I know we have been in communication with your sister, and your sister actually texted Miss Lassequat, I don't know who that is, to make sure you were okay. We told her physically we had laid eyes on you.
I just want to make sure that, again, viewers know, the fact he got no PIN number, the PIN is necessary to make a phone call. It's a code that they give inmates so they can make a phone call so that it gets charged to their account and that they know who they're recording when they make that phone call. And that's why they enter a PIN number. So what he's talking about is he didn't have the ability to make a phone call because they never gave him his PIN number.
Then he says, I'm talking about locking me back up. We would have to bring charges. There would be no incentive. Y'all will. We've already had this discussion. Look what you did to me. You waited till Friday to do this. I done told you every day before Friday I was pleading the 5th. So again, he says he was pleading the 5th, and they screwed him by making him stay in jail all weekend. No, you didn't. As a matter of fact, our last, Mr. Copeland, this is the court jumping in. Let's see if we can get beyond this, okay? Beyond what your concern is. So this is the judge stepping in, trying to ease the witness's concern. You could have invoked your Fifth Amendment privilege. The state could have turned around and said, stop, had me go ahead and filed the motion to give you immunity. It was going to, they make that decision. They decided on a Friday. He's saying, so that could have been procedurally how it happened, but instead they just went ahead and gave you immunity. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking your Fifth Amendment privilege, so they give you immunity. So they gave you immunity, so you've got to testify.
Now, right there, 44, if you go up a little bit, that's where the court steps in and starts going through the actual immunity order that he entered, giving him immunity. And he explains that order in detail to Copeland. So this is the court speaking now.
Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in the order. The only thing that will get you in trouble is the next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. So that's pretty much exactly what he's worried about, because all he does is lie, which is what he said.
And by the way, there's nothing wrong with a judge reading an order to a defendant. That part there, that made sense that the court was actually telling him what the order said.
I think a lot of what the judge did in the hearing makes sense if the criminal defense attorney was standing right there.
Yes, absolutely.
Right? What the prosecutor did, I think the criminal defense attorney would have blown up and been just horrified. But what the judge did throughout here, and what he actually said, maybe what he didn't do would have been problematic, but what he said, I don't think he would have said any differently if there was a defense attorney in the room.
Right. And that's us trying to be fair, and balanced in how we're explaining this, and that the judge's problem was he was asleep at the wheel when this was going on. There are things he should have done and didn't. His was basically a sin of omission, of not doing what's right. The prosecutor, that's a sin of commission. They committed repeatedly ethical violations and legal violations during the course of this, and the judge should have held them accountable and didn't. And that was the judge's problem, was he sat on his hands and let the prosecutor get away with whatever they wanted to get away with.
So the prosecutor then says, but what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday, see the dogs deliver their babies, go talk to your nephews, and do all these other things. Does that sound like coercion to you?
Sounds like trying to influence, yes, rather than just explaining the order. That's fine.
And he
Going
says,
beyond that, that's a question.
and he says, how do you know about my dogs? She says, because you told me. He's like, okay. Bumpus says, what's wrong? And Copeland says, I'm stressing at another level. Like, Bumpus said, I mean, Copeland said, I'm weak, man. I'm not playing. I'm dead serious, man. Like, Hilton says, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And, you have to make, and Bumpus says, if he decides in 2 weeks he wants to testify, then what? Hilton says, if he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. Bumpus says he just feels like he's under a lot of pressure right now, this second. Even at the jail, they are just, you can't give me house arrest. Hilton said, no, you can go home by taking the stand. And the court said, and come back tomorrow. We keep on saying yet, but there's no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You haven't done anything wrong so why am I in jail? Copeland says, because you aren't testifying, but that ain't nothing wrong. It's not a crime. It's not a crime, but you're in civil contempt. So now they're trying to explain to him the difference between a crime and civil contempt. Were you going to say something?
No, I'm just looking
Then he
at you.
explains again why he's in jail for refusing to testify. Copeland says, you can't just sentence me. And Bumpus said, there is no sentence. Court says there is no sentence. Contempt is compliance. They want your testimony. That is all they want, whatever that may be. I don't know what it is, Your Honor, Copeland says about his own testimony. Hilton says, so listen, you're in jail for failing to testify, not for anything else. There is no crime. You ain't done nothing wrong. I don't know if people are telling you what we are going to charge you with. Nothing. We are not charging you. The state charges you. There's nothing we're charging you with. You are only in custody because you've decided not to testify. That's it. And we got to remember, all this happened after he said potentially he would falsely say that he committed a crime he didn't actually commit. And there's no reassuring.
And also notice what's missing here is fear of his life or fear of some kind of retribution. That's totally missing in these arguments. They say, oh gosh, he's in fear of being killed for this. Well, if I look through this, the prosecutor doesn't give a rat's about that. They didn't mention it once when they went through here, and he doesn't mention it either.
Yeah.
And that's going to be important later, because that's going to be the defense here of the judge and the prosecutor, is that this had to be ex parte because of the fear for retribution for what was going to happen to him if he testifies, yet they really don't deal with it.
Yeah, it was really just more of talking him into testifying, giving him all the reasons why he should testify, what he can say, what he can't say, how he should answer questions, and how no matter how he answers, they're not going to prosecute him. That's really what it's about.
Yeah, and the only thing he's scared about is being prosecuted. That's it.
Right. Actually, just being thrown in jail.
No.
Then they get into how he can purge and get out of jail, and he explains how purge means you do what we want you to do and you get out of jail. And he talks about how it's different than perjury, and the judge kind of explains that to him. Bumpus says, you've got to make a decision. So if he starts testifying today, he's going home today. Hilton said he should, as long as he remains. But if you get up there and be like, if you don't get to testifying, and then we get into, you start saying, I plead the fifth, we're going to be back here again. Bumpus said, but if he says he don't recall to everything, he'll be okay. Hilton said, I'm not advising that, but so long as he answers the questions, that's fine. And Copeland said, I did these crimes. I'm telling you that. So again, a statement that a witness makes that is incredibly important to the defense's case and potentially exculpatory. This is Brady information. And guess what? If he goes out and he takes the stand and he does not admit to crimes and he says, I didn't do them, this is a statement under oath the defense should be able to impeach him with. Like, this is important. And I realize this witness on the stand is a little bit, and he's got some inconsistent statements and some issues, but this is still important for the defense to have. This is like the definition of Brady material. Okay, I don't know what you're talking about, but I think, so he says that I committed these crimes. She's like, all right, I don't really know what you're talking about. And Bumpus said, I think, or what you're saying is you're going to get up on the stand and say something, and Copeland has no response. And Bumpus said, did we find out if he could talk to his family? Hilton says, I mean, if it's okay, we got his sister's number. as my attorney, you gotta let me, if y'all want to talk, let me go somewhere where I can't hear you. Oh, that'll be a change. They're not going to overhear a conversation between him and his lawyer. The judge is over there, so just speak low so he doesn't hear you. Hold on. Judge Glanville handed a document to Caleb Bumpus, exited the chambers. Okay. Then the court says, okay, all right, Mr. Copeland, have you had an opportunity to speak with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? He said, no, Your Honor. Is it your desire to give testimony today? Yes, sir. So that's how it ended. And that's important as well. I wish we had a transcript of how it ended the first time before he got on the stand and pled the fifth, but we don't have that because it wasn't recorded, and we just have to take people's word for it. Copeland said he told him he was going to plead the fifth. The state attorney says he said he was going to testify. All right, and then they start to get into what size are you, and there's nothing else really that we need to get in with the transcript. But what I want to ask you is, overall, what are your thoughts now that we've heard the transcript? We've heard what the judge says, the judge's arguments. We know this hearing is coming. We'll see if another judge sees it the same way as Judge Glanville.
All right. Okay. Again, here's the balance. Glanville, he holds his hearing because the state requests it. Fine. The state can request a hearing. Then he should have asked the question, what is the emergency? Why do we have to do this ex parte? He really didn't do that. And we also know that after this hearing now, he's made a decision that it shouldn't have been ex parte. Otherwise, he wouldn't have turned over the transcripts because nobody else, no other judge is ordering him to turn the transcripts over. It's the decision he made. So he made a decision. There's nothing that happened in that hearing that the defense can't know, number one. Number two, he should have decided that during the course of the hearing when he discovered that there really wasn't an emergency. And therefore, he should have stopped the hearing and he should have allowed defense counsel to say, look, we're not going any farther until defense counsel is here at the hearing so they can be represented. He should have done that. His defense is going to be that this was a situation of retribution against the witness, so that's why it was an emergency, which there is case law that says you can't have an ex parte for that. That's his defense. But if you read the entirety of the transcript, it shows nobody was focusing on retribution. Nobody was focusing on him getting hurt because he testified. They were all trying to intimidate him into testifying and not take the fifth. It was all about that, nothing else. So the emergency nature was zero zilch, even though they're going to claim it. His sin was he did not do what a judge is supposed to do. The prosecutor was absolutely the worst. We learn all sorts of stuff about the way they conducted themselves, but it's up to the judge. He's supposed to be the neutral guy that sits there and calls balls and strikes and makes sure that a defendant gets a fair trial. He didn't do that. That's really the bottom line.
The only thing I can think of as we read this entire transcript is the defense attorney being there would have solved all the issues. There's no reason not. It's not like if anything, the state attorney accused this witness and his lawyer of conspiring with the defense attorneys and the defendants more than she accused them of potentially doing physical harm to this witness or potentially learning something that would be dangerous for this witness, which would be a reason to keep the defendant out if that was going to immediately put his life in danger. But instead, she's saying, I don't know whose interest you guys are looking out for. And he's saying, I did these crimes. All I've been doing is lying. All that stuff is good for the defense.
Plus, think how the atmosphere would have changed if when Steele got up there and said, there was this ex parte hearing, and judge goes, you know what? You're right. I acknowledge that we have the ex parte hearing, Mr. Steele. You know what, Mr. Steele? I'm turning over the transcript to you here. This is going to be all done. Then, read the transcript, and then you can come back and make whatever arguments you want. Just think how much different this would have turned out. But instead, he was, again, the cover-up was worse than the crime. Again, he tried to cover this up. I mean, he really did. And I'm really surprised because he really shouldn't have. He just should have turned the transcript over. Yeah,
and that's the annoying part and the frustrating part. But I mean, this case is like never ending. So from what you saw in the transcript, do you think that they will recuse or disqualify Glanville from continuing on this trial? Do you think anything that happened in this ex parte hearing would cause for dismissal of the trial or anything to that level of a remedy?
No, there won't be a dismissal of the trial. In the law in Georgia, interestingly enough, if another judge is appointed, he actually can take over at the spot that this happened in the trial. Now, I don't know how that can possibly happen in a trial. It's been going on since November, but that's one of the options that the courts have. I don't know if it's going to be enough. I got to be honest with you, because judges, of course, give the presumption of correctness to other judges when they're looking through these transcripts. And if you look at just the words of the court, just the words of the judge, they aren't as horrible as the prosecutor. I don't know if omission is a reason for him to be disqualified. So I got to be honest, it's not a slam dunk win for the defense that they're going to recuse him. Go ahead.
I am pretty horrified at the conversations that were happening, but I did think it was going to be worse coming from the judge than it was. So I could see this one going either way, kind of like you're saying too. If I had to bet, I would say he's not going to be recused, especially if they pick a judge from his jurisdiction. And I don't think it rises to any level to dismiss the case, but I definitely think the defense should be able to use everything that was said, including what the prosecutor said to Mr. Copeland, and the jury should get to hear that.
Oh yeah, there should be wide latitude in cross-examination on this. The judge should let them just rip the prosecutors apart from this transcript.
They're giving you federal immunity, and they don't even have the ability to do that.
Right, and they're wrong. And they're wrong on what they advised him, and did all sorts of stuff to trick him to testify. And these were tricks. He was tricked into waiving his Fifth Amendment right. But yeah, it's going to be, and I tell you another thing, and this is kind of a side note, but Ms. Bumpus gave an interview and was asked, were you the one that revealed what happened in this hearing to Mr. Steele? Were you the initial person to do that? And she said, no, she was not, that they knew about it already from another source. Then later on at a break that day, she met with 4 of the lawyers and did disclose what happened, but they already knew about it before she told them. And so I thought that was an interesting fact. So now the prime suspect, prime whistleblower, as we would call her, is not the prime whistleblower. There is somebody else out there that revealed this to the defense.
Yeah, that's interesting. I wonder if it was Copeland himself or
maybe one of the court personnel. Maybe a court personnel made a comment or said something, offhanded, innocent comment, and the defense lawyers picked up on it.
Yeah. Yeah, that's really interesting. I mean, to think that this all can happen and think the defense lawyers aren't going to find out about it is pretty wild. So where we go from here is we take a break. We wait for this recusal hearing to happen. Then we come back to trial. They get to use all of this when they cross Kenneth Copeland, which is happening at some point. But this is going to take forever.
Yeah, another thing too. What about these jurors? Think about it. First of all, it's got to be it's got to be assigned to another judge to hear this hearing. Then there's going to be this big hearing.
Well, they won't know about that necessarily, but
no, they won't know about it. But it's the delay. They're going to sit at home for weeks, maybe months before this trial starts again. And by the way, interestingly, the judge has his own attorney at that hearing. So the judge will be represented by a lawyer who's going to represent him at that hearing. So that's going to be interesting as well. And I'm sure that, we'll hear about that hearing when it happens, but they asked the judge, the prosecutor asked the judge, can we speed this up? Can we do something? The judge says, look, I have no control over how long this is going to take.
Yeah, I mean, and that's really what it's going to come down to. And we're just going to continue following it. Throw your questions in the comments. We'll take a look at them. We're going to do a live eventually. We can get our schedules linked up and synced up so that we can answer your questions live as well. Make sure you guys hit the like button if you haven't already and subscribe to our page. But until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.